Hello friends, my name is Natalia Porsche, and in this video I will tell you why you cannot get divorced in the state of Mississippi. Who doesn't know me, I'm an attorney who has a general law practice law firm in Mississippi, and one of my areas that I practice is family law. So there are several factors that affect your capability of getting a divorce in the state of Mississippi. First of all, residency requirements. Okay, so if you are not a resident of the state of Mississippi, you cannot get divorced in the state of Mississippi because you have to be a resident here for at least 6 months before you file your complaint for divorce. Number 2, improper service of process. After you file your complaint with the clerk of the court, of the chancery court, where in jurisdiction where you're seeking your divorce, you will be issued summons. And if you have an attorney, your attorney will be able to prepare all the pleadings, all the paperwork for you. After clerk issues summons, you must serve your spouse. Process of service is very important, and it is outlined in Mississippi Rules for Civil Procedure. It says that you must serve a person within 6 months. You have 120 days to serve your person before you can ask for extension of service, right? So if you are unable to serve your spouse within 120 days, you can ask for extension in order to serve your spouse, okay? Because let's say for one of the reasons you cannot serve your spouse because you cannot find your spouse. If you know the address, the last address where your spouse has been residing. Now, here's very important information. If you don't know where your spouse is, then you can serve your spouse by publication. Publication is, you can find the rules for publication again in Mississippi Rules for Civil Procedure. Publication, it's you must publish summons every week for 3 consecutive weeks in a local newspaper. So therefore, the service of process is very important ingredient of whether you can get divorced in the state of Mississippi. For example, if you file your complaint, then the clerk issues summons, but you are unable to serve your spouse with a complaint and summons, letting your spouse know that there is a divorce pending action in the state of Mississippi against your spouse. Therefore, you cannot get a divorce. Number 3, you cannot get a divorce in the state of Mississippi if you are seeking a contested divorce and you cannot establish for one reason or another one of the grounds of 12 grounds, fault grounds for divorce in the state of Mississippi. Now, let's go back to number 2. Let's say if you serve your spouse, you have been a resident in the state of Mississippi for 6 months before you file your contested divorce. And contested, what I mean by contested is that your spouse is contesting that you should be entitled for a divorce. So that means you're disagreeing. You're disagreeing, let's say, with child support or child custody or any other property distribution if you have any marital property. Again, this is very complex issue. You must definitely have a consultation with an experienced attorney if you're seeking divorce in Mississippi. But here's how it works. If you have children, you don't know where your spouse is, you file your complaint for divorce based on one of the contested grounds, and now you're seeking adjudication. Let's say the court will grant you a divorce because let's say you was a victim of domestic violence. So you will get divorced. You might get a divorce. Again, this is not an attorney's advice, all right? Maybe based on a cruel and inhuman treatment under full ground in Mississippi. But again, child custody, the court might give you child custody, full physical. But as far as child support, there is an issue because if we don't know where the spouse is, we don't know his income, he was not subpoenaed to come to court, he was not found, right? For process of service, there is an issue how the court will establish child support. Now, I saw a lot of judges granting contested divorces based on the fact that the spouse is not present in the state of Mississippi and the spouse, the innocent spouse, does not know where this party, where the spouse who is at fault for divorce, where he is or she is located. So therefore, and does not know the P.O. box box address, right? So PO box, postal office address also does not know. So you must also make allegations that you don't know the post office address of your spouse, not just physical address. So now you have child custody dispute as far as child support. Unfortunately, the court can reserve the determination of the spouse of the child support amount for the future, set this, let's say, for a hearing in the future, and you can have this in your final judgment that the court reserves determination of the child support amount for the further date. However, at that time of the divorce, likely you will not be able to get the amount of the child support that the other spouse who is at fault for divorce will be paying you. So you might, need to proceed later on with amount of the child support. So again, there are very, very strict requirements for divorce in the state of Mississippi. You have to be very careful when you file. You don't want to waste your time and money because there is a filing fees that you must pay at the time when you file for divorce. And remember, every complaint you file must be supported by affidavit signed before a notary public under oath that whatever you're saying in your complaint is true and correct to the best of your knowledge, okay? And definitely, please consult with an experienced attorney. If you have a divorce in Mississippi pending, you can call our law firm. The phone number is down below. It's 228-229-7500 and set up your consultation and speak with an experienced attorney before you decide to proceed with your divorce action. And talk to attorney whether you even eligible to file for divorce, whether you can even establish one of the fault grounds, because you also must prove your claim for divorce, not just to file a complaint, okay? You must submit evidence down the road later at your court hearing. You must submit evidence that you are actually entitled to a divorce. And it can be very tricky, for example, a fault ground like adultery, right? It can be very tricky because you must have your evidence. You must have clear and convincing evidence for the court to show that your spouse was not faithful towards you, did not forgive your spouse, right? Because reconciliation, as we all know, is also a defense. If you reconcile with your spouse, if you accepted him being unfaithful, if you had some kind of agreement between you two, maybe open marriage or any kind of possible agreement, then guess what? You waive your claim because you knew what happened. You reconcile and you accepted your spouse to be the way he or she is, right? Because let's say he or she cannot change. Therefore, very important to consult with an experienced family law attorney as far as your divorce, whether you're entitled for divorce. And again, a lot of people thinking about doing irreconcilable differences divorce, but sometimes irreconcilable differences divorce take longer than contested divorces. And irreconcilable differences is when you guys both agree to a divorce. It's a non-fault ground divorce. You both agree as far as the child custody, if there are any children involved in this dispute, property settlement agreement, if you have a house that you're trying to divide, right? So it's very complex and you definitely must consult with an experienced family lawyer attorney in your jurisdiction. Again, thank you so much for watching this video and sign up for my channel on YouTube. Call for a consultation. It's 228-229-7500 and all the best to you. Good luck. Bye.